Hello friends, welcome to Abhinav Goswami Law Classes. So friends, in this video, we are going to discuss section 14 of Indian Evidence Act, a very important provision. Why I am saying so? Because that it tells you how you determine whether a particular person had intentions or not, ill will or not, all those mental aspects which are very hard to prove. So it tells you the way. So that is why it becomes so important. So friends, if you have your BREC with you, please open it up, open section 14 in your BREC, and I'm going to start reading from there. Okay, so section 14 heading reads, facts showing existence of state of mind or of body or of bodily feeling. Very important. Okay, so facts showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will, or goodwill towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or body or bodily feeling is in issue or relevant. Very important, yet very easy also. See, the first thing that you must understand as far as section 14 is concerned, that all those facts which are either indicating or going against what, whether a particular person had a particular intention or not. See, most of the criminal provisions of Indian Penal Code requires intention, mens rea. So all those facts which are indicating towards whether this person had the intention or not, whether he had knowledge or not, whether there was good faith or not, whether he was negligent or not, whether he was working in a rash manner or not, whether he had ill will towards a particular person or not, or whether he has goodwill towards some particular person or not. So all these facts, if you see them, intention, knowledge, good faith, negligence, rashness, ill will, and goodwill, what are they? They are a state of your mind. They are not tangible things. You can't see them. You can't feel them. It is something which is in the mind of a particular person. So you can't see it, obviously. How will you tell? How will the court decide whether this particular person had bad intentions or not? How will you say that? You can't see it. Obviously, there can't be no medical examination of data for determining the intention. Not possible, because whatever is in the brain, no one can take it out as it is. So what is the other way? What is the second option with a court of law? It has to make out whether this particular person had the intention or not from other facts. What are those facts? Those facts which are compatible with that intention. How will that happen? For example, if a particular person is being prosecuted for the offense of murder, okay, so the fact in issue is A has murdered B, whether A has murdered B. So there it is clear that A has killed B. Okay, A used a knife with which he stabbed B and he died because of it. Actus reus is proved. The only question is whether he had intentions or not, because in order to be punished for the offense of murder, intention has to be there. So how will you determine the intention facts? From other facts. What will be the fact? That A and B had a rivalry between each other. They had altercation with each other. B was abusing A, or A was jealous of B. They had bad relation for long time. So what are these facts? What are they indicating? All these facts are indicating that there was intention on his part. Okay, so that is the reason it becomes very important. This intention part becomes very important. The second, if we take our example of knowledge, how will you know whether a particular person had knowledge or not about a particular fact? For example, if a particular person of 20 years of age, for example, he drove his car at a very high speed in a crowded space, very high speed. So how will you determine whether he was aware of the fact that if he did so, a lot of people will die? How will you decide that? You will decide taking into consideration his age, his knowledge level, his education level. So all these facts, what are these facts? They are indicating towards where that as a normal person, he must have knowledge of the fact that if he did so, he is going to kill a lot of persons. Okay. So that is the reason that it becomes so important. Okay. What is the third fact that we need to talk about? It is about good faith. What is good faith? How will you decide whether a particular person is having good faith or not? So, good faith is something which is in your heart, that you are acting and you are helping something in good faith. Though you may be, so when we did general exceptions of IPC from section 76 to 106, there was many sections which were talking of good faith, that if you injured someone in good faith, then you are not for his own benefit, then you are not, you will not be punished for that. So how will you determine good faith? So you will determine good faith from the fact that there was no rivalry between them. In fact, this person was a good person and he wanted to help. Okay. And it is also evident from the fact that he tried to help other people also. So these are all the facts which are indicating on good faith of particular person. Same goes with negligence also. Okay. So the fact that a particular person knew that the brakes of his vehicle are not working properly, still he took that vehicle out and drove in a crowded place. What is this fact showing? This fact is showing that he was negligent. That's why it becomes relevant under section 14. Same goes with rashness also. Same goes with ill will. What is ill will? Ill will is something that you think bad things about a particular person. You don't feel good about someone. Okay, that is a normal meaning of ill will. So how will you determine whether a particular person had ill will or not? From the previous conduct. Was this person treating the other person in a good manner? What was the state of relations between them? If there was a dispute, what was the cause of the dispute? What was the status of that dispute as of now when the offense was committed? So all, what are these facts? These are all indicating the ill will of that person. And finally, goodwill. Goodwill is just opposite of it. For goodwill, you have to see that the particular person was in good sense. He wanted to help. So we will see the previous conduct and everything. Okay. So all these things, intention, knowledge, good faith, negligence, rashness, ill will, and goodwill, all of these are mental states. So you can't, there cannot be explicit evidence of these things. So you have to rely on other facts which either support or do not support or disprove all these mental facts. Okay. So all these facts which are indicating intention, knowledge, good faith, negligence, rashness, ill will, or goodwill, they automatically become relevant under section 14C. That is the reason section 14 is so important, because all the all the circumstantial evidences automatically becomes relevant under section 14, because most of the, see, when you do not have a explicit evidence of a particular thing, when you do not have explicit evidence of a particular thing, what you rely on? You rely on circumstantial evidence. Same goes with all these mental facts, because all these facts which are indicating mental status of a particular person, there cannot be any explicit evidence. So what you rely on? Circumstantial evidence. So most broad category of circumstantial evidences is included in section 40. So when you start litigation, no, or when you go into the practical areas of law, you see section 14 is very, very important. A broad category of facts which decide on the issue whether this particular person will be punished or not go around this issue. Okay, so very, very important. Now move forward. This was the first thing that section 14 does. It tells you about the mental state of a person. Okay, facts which indicate about the all these mental aspects of a particular person. The second thing which this person talks about is or showing the existence of any state of body or bodily feeling. So the second category of facts that become relevant under section 14 are which are telling you about the state of body of a particular person. What is meant by this term state of body? State of body is whether your body is healthy, whether a particular person was suffering from any disease, or was he weak, Okay, so was he suffering from any particular wound? Okay, or so all these facts which are telling about the state of body. The first category is telling you about the state of mind. The second category is telling you about the state of body or bodily feelings. Bodily feelings, it means only the pain which you are feeling because of a particular thing, or the pleasure. So all these are bodily feelings. So as far as section 14 is concerned, it targets two category of facts. First category of facts which prove or disprove all these mental aspects about the brain, about the mind. Okay. The second category of facts which talk about the state of body, your physical body. So it covers the entire human being. Okay. So this is what section 14 is about, the main law, the main thing. Now come to explanation. Explanation 1. A fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to the particular matter in question. This is very important. What explanation 1 is trying to say is that as far as all those mental aspects which we are dealing with now, intention, knowledge, and everything, whenever you are investigating a particular crime, or whenever a particular fact in issue is before the court of law, the court do not decide on the basis that what was the normal state of mind of a particular person. No, whether he was of angry nature, or whether he was of a calm nature, or whether he was was into fighting at all times. No, not at all of that is not relevant. Mental status of a particular person in respect to that dispute, that is relevant. So maybe it may be possible that normally a particular person is of a very furious nature, he is always angry, but at that point of time he was of very good faith. So are you going to punish that person just because generally he's of angry nature? No, no. What is relevant? What was the behavior, mental state of that person in relation to fact in issue? That particular matter which is an issue before the court, in relation to that, what was the mental condition of that person? This is very important. This is explanation 1. Now come to explanation 2. But where, upon the trial of a person accused of an offense, the previous commission by the accused of an offense is relevant within the meaning of this section, the previous conviction of such person shall also be relevant. Now we will be saying that what explanation 2 is saying, that if in a particular trial, if you are accepting it, if the court is accepting as evidence that this particular person was previously brought before the court of law in regard to similar nature of crime, then you also need to take into consideration whether in that case, whether he was convicted or not. It will also be accepted as a relevant fact because they are interrelated. Why there was need of explanation to see, as far as criminal law is concerned, no, or any particular offense is concerned, the court of law is always concerned about one question: whether a particular person committed the crime which is a fact in issue before the court or not. The court is never concerned about the previous behavior of the convicts or normal conduct of that accused person. No, we are only concerned with whether this person did this offense or not, as simple as that. So you will see in movies also what these lawyers do. They try to bring in previous conduct of these persons, that this person has also done that offense and he was convicted in that offense, so he must have done this also. This is what happens. So as far as section 54 of Indian Evidence Act, only we'll reach that at one day, we'll reach that section also. But as far as section 54 of Indian Evidence Act is concerned, it prohibits such evidences because they have no direct relation to the fact in issue. Okay, so what was the previous conduct or previous behavior or previous nature of those persons which are independent of fact in issue, they are, or they should not be admitted as relevant facts in a court of law. This is the normal rule. So what this explanation is doing, explanation is making an exception. It is saying that you can admit the fact that whether this particular person was accused in a previous case or not. But if you are taking this evidence If you are admitting this relevant fact, then you also need to go into detail whether he was convicted or not. Not only accused, whether he was convicted for the, he got the punishment or not. Both of, if you are going to admit, you have to admit both the facts. You can't only just say that he was accused in that, because lot of people are accused in a lot of crimes, you know. Not all are convicted. So conviction is something. What is meant by conviction? Conviction means that the court of law has reached the conclusion that this particular did something wrong. Okay, so only when a particular person is convicted, that fact has to be taken into consideration along with the fact that he was accused. Okay, so this is what explanation 2 talks about. Now come to illustrations, very important illustration. Illustration 1. A. A is accused of receiving stolen goods, knowing them to be stolen. It is proved that he was in possession of a particular stolen article. The fact that at the same time, he was in possession of many other stolen articles is relevant, as as tending to show that he knew each and all the articles of which he was in possession to be stolen. See, beautiful illustration about the mental state. So, what is the fact in issue in this case? That A has been apprehended with particular goods in his possession. So he can't deny that he was in possession of those goods. That is clear. And those goods were stolen goods. That is also proved. But the only question that is there is whether A was aware that they were stolen goods or not. Only then you can punish him for possessing stolen goods. Only if he was aware of them. So how will you know? How will you decide whether he was aware that they were stolen goods or not? So all the facts which indicate in the direction that he was aware or not aware that they were stolen goods becomes relevant because of section 40. And if a fact comes before the court that there were other articles also in his possession which were also stolen. So what is this fact? This fact is indicating that why will a normal person will have so many stolen articles in his possession? Just the only result, the only thing that we can presume from this is that he was aware of it. In fact, he was dealing in stolen goods. Only then he will if such a person will be in possession of so many stolen goods. So this fact that there were other goods also which were stolen in his possession, they become relevant because of section 40. Illustration B. A is accused of fraudulently delivering to another person a counterfeit coin, which at the time when he delivered it, he knew to be counterfeit. The fact that at the time of its delivery, A was possessed of a number of other pieces of counterfeit coin is relevant. The fact that A had been previously convicted of delivering to another person a genuine, a counterfeit coin, knowing it to be counterfeit is relevant. Illustration B. What it is saying? It is saying that a particular person is apprehended while he was delivering a counterfeited coin to another person. He was apprehended. So now obviously this person will claim that this person A will claim that no, I was not aware whether it was counterfeit coin. This happens so many a times. Counterfeit coins or notes come in our possession also, and we are not aware whether it is genuine or not. So he will take that defense. No, I was not aware. So how will you prove that he was doing it fraudulently and intentionally? So the only way is if he's found, if a lot of coins, such counterfeit coins are found from his possession, what is this fact indicating? That one or two coins may come in the possession of a unaware person, but what are you doing with so many coins? That means that you deal in counterfeit coins. So this is a fact indicating that he was aware of it. That's why it becomes relevant under section 40. And as far as second part is concerned, which says that the fact that A had been previously convicted. So what is this? This is explanation 2, that this person was previously convicted. Mind the word convicted, not accused, as per explanation 2. Convicted, this fact that he was previously convicted for the similar offense that he was dealing with counterfeit coin is also relevant, because what is this indicating? It is indicating that as he was previously dealing in counterfeit coins, we can presume that he is also doing it again. Yes. So that's why it becomes relevant under explanation 2. But we have to take the evidence of conviction. Okay. Now come to illustration C. A sues B for damage done by a dog of B's. Okay. Which B knew to be ferocious. The fact that dog had previously bitten X, Y, and Z, and that they had made complaints to B are relevant. So what is happening in this case? A is filing a case against B because B's dog has bitten A. So what will B say in this such a case? That, oh, I was not aware that my dog is like that. I was not aware. It was completely intentional. So what are the facts that will show that he intentionally did it? B was aware of it. Still he left his dog free. What will the that? The fact that on previous occasions the same dog had bitten X, Y, and Z, and those three people had already complained to Bet that your dog is of a ferocious nature. You should control him. Still you allowed it to go out and bite A. That means that you were negligent. Okay, so it becomes relevant. D. The question is whether A, the acceptor of a bill of exchange, knew that the name of a payee was fictitious. The fact that A had accepted other bills drawn in the same manner before they could have been transmitted to him by the payee, if the payee had been a real person, is relevant as showing that A knew that the payee was a fictitious person. So what is happening in this case? That A is a person who is a acceptor of bill of exchange. Okay, so the pay who is mentioned in that is a fictitious. Okay, fictitious means that he is not a real person. He is just some identity or some particular individual who does not exist. Okay, so he is dealing in such bill of exchange. So obviously he will claim that I was not aware that he was the pay was a fictitious person. So the fact that on the previous occasions also he has dealt in such bill of exchange, he has accepted such bill of exchange with his fictitious name, so that becomes relevant. Okay, so now come to illustration E. A is accused of defaming B by publishing an imputation intended to harm the reputation of B. Very simple. The fact of previous publications by A respecting B showing ill will on the part of A towards B is relevant as proving A's intention to harm B's reputation by the particular publication in question. The fact that there was no previous quarrel between A and B and that A repeated the matter complained of as he heard it are relevant and show that A did not intend to harm the reputation of B. So see, illustration E is one of the most balanced illustration. It provides for both of the scenarios. So what is happening in this case? Illustration E, that A is accusing B. Now, A is a person who has defamed B and B is accusing him. Okay, B is saying that you have defamed me by certain publication, you have harmed my reputation. This is the main issue. So what obviously A will take, no, I had no intention of defaming you. What I was saying was truth and all. So what are the facts that will become irrelevant because ill will has to be there for defamation? So what are the facts that become relevant in this case so as to prove the ill will of this person accused? So if a fact comes before the court of law that on previous occasions also A had published certain matters regarding B, which were also of defamatory character. What is this fact showing? That A is continuously trying to defame B or harm his reputation. So this is a clear indication of ill will on the part of A towards B. Okay, but on the contrary, there is no such evidence that comes before the court of law. Instead, what are the evidences that are coming before the court of law? That there was no previous quarrel between A and B. Okay, and what A has actually written in his newspaper or magazine is what he heard from the society. So what are these facts showing? That there was no ill will, there was absence of ill will, no previous quarrel, and he wrote what he heard. So he did not make any additions or exaggerations. So they become relevant as to prove that he had no ill will. So these facts, not necessarily all the facts has to be proving all those mental conditions. All those facts which are disproving those mental conditions, they are also relevant under section 40. Okay. Now come to illustration F. A is sued by B for fraudulently representing to B that C was solvent, whereby B being induced to trust C, who was insolvent, suffers loss. So what is happening in this case? A is a person who has played fraud on B. What A said to B? A said to B that this person C is a perfectly solvent person. He is a rich person, and on the basis of this trust, B lent some money to C because A said so. Okay, but what it turned out to be that C was an insolvent person. He had no money at all, and he ran away with the money which B gave. Okay, so obviously B will sue A. So what are the facts that will become relevant? The fact that at the time when A represented C to be solvent, C was supposed to be solvent by his neighbors and by persons dealing with him is relevant as showing that A made the representation in good faith. So if a fact comes before the court that when actually A represented to be that C is completely solvent, at that point of time no one had knowledge. All the persons who were dealing with C, or all the neighbors, or all the normal persons who were in direct contact with C, they were not aware that C has become insolvent. So obviously we can't expect A to know that. So in such scenario, A made such a representation. So he made that representation in good faith because he was thinking that was true. So it becomes relevant so as to disprove that mental condition. Okay. Now come to illustration G. A is sued by B for the price of work done by B upon a house of which A is owner by the order of C, a contractor. Okay, what is happening is A is being sued by B. Okay, what is happening? So B is suing A because B has done certain works for A. Okay, so obviously for the money which A owes, B is suing A for that. Why B did that work for A? It was on the order of C. C has asked B to do certain works for A, and as a response to that, B did certain works for A. And now, as A did not pay the money, B is prosecuting A for that money. So what are the facts that will become relevant? A's defense is that B's contract was with C. The fact that A paid C for the work in question is relevant as proving that A did in good faith make over to C the management of the work in question so that C was in position to contract with B on C's own account and not as agent of A. So in such scenarios, when B is suing A, when B did work on the order of C. Okay, so obviously what will be the defense that A will take? A will say that no, you had a contract with C. B and C had contract with each other. B, you did not have any contract with me. A is saying that. So how can you ask money from me? So what are the facts that will become relevant in such case? So the fact that A had already given money for the work that was required to be done to C. He had already given money to C. And this fact, what is this fact showing? That A is in good faith in this case. He had already paid money to C, and now it was for a contract between C and B. C had to pay the money to B, not A. A has already done so. Okay, so as far as A is concerned, A is alien to contract for between B and C. So if B was not paid any money, who is the person he should prosecute? Is the C, is a person C with whom he had the contract. Okay, because C was not acting as an agent of A, he was acting as an independent contractor because A had already paid the money to C. Very important illustration. H. A is accused of dishonest misappropriation of property which he had found. And the question is whether when he appropriated it, he believed in good faith that the real owner could not be found. Very interesting. Okay. So this requires you to have the knowledge of misappropriation of property provided by section 403 of Indian Penal Code. Okay. Let's come to know that. So what is happening is this case, there is this person A. He is being prosecuted. Why he is being prosecuted? He is being prosecuted for the reason that, what is the accusation? That you have misappropriated a particular property which you found. Okay, so what is the law that requires people that if a particular person has found something, he has to make efforts to find the real owner. And only when, after making all the efforts, he was unable to find the real owner, only then he can convert the property for his own use or keep the property. So in this case, accusation is that you kept that A has kept the property, misappropriated the property without making genuine efforts to find the real owner. Okay, this is the accusation. So what are the facts that will become real? How will you decide whether A made genuine efforts or not, whether he misappropriated the property in good faith or not? So what are the facts that will become relevant? The fact that public notice of the loss of the property had been given in the place where A was is relevant as showing that A did not in good faith believe that the real owner of the property could not be found. So the fact that the real owner had advertised everywhere in the place where A was residing that I have lost this property. So what is this section then? He was aware about the real owner, still he did not return the property and misappropriated it. So what is it showing? Absence of good faith. What is the other fact that will become relevant? The fact that A knew or had the reason to believe that the notice was given fraudulently by C, who had heard of the loss of the property and wished to set up a false claim to it is relevant as showing that the fact that A knew of the notice did not disprove A's good faith. Okay. uh, if for example the same notice which we are talking of, that which was telling that I have lost the property, so for example on the basis of that notice A has inquired as to whether this person who is giving the notice is the real owner or not, and when he inquired about it he found that C was not the real owner. In fact, he was playing a fraud so as to appropriate that property. If because of that A did not return that property, what is it showing? It is showing that there was not absence of good faith. He was doing the right thing as he became aware about the fraudulent nature of C. Okay, so that also become relevant so as to show that there was good faith on the part of A. Okay, so I can see there are now come to we have already done. Let's come to I. Okay, A is charged with shooting at B with intent to kill him. Very important. In order to show A's intent, the fact of A's having previous shot at B may be proved. Very simple, very easy illustration. I'll say what is happening in this case. The A has shot B, so the prosecution is against A that you have committed murder. What is required? Intention is required. So A will say no, I had no intention. It was a mistake. This is what he will going to say. So the fact that on previous occasions also he has tried to shoot B goes on to show that he had the intention. Okay. J. A is charged with sending threatening letters to B. Threatening letters previously sent by A to B may be proved as showing the intention. Same facts. Same facts on the previous, because whether those facts were threatening letters were sent by A or not, or whether they were sent intentionally or not, both of the facts can be proved by the fact that on the previous occasions also same nature of letter was sent by A to B. Okay. K. The question is whether A has been guilty of cruelty towards B, his wife. Expression of their feeling towards each other shortly before or after the alleged cruelty are relevant facts. So B is the wife. B is prosecuting her husband A, that you have been treating me with cruel behavior. Uh, you have very bad behavior towards me. Okay. So what are the facts that will become relevant? So what are the feelings that they have towards each other when this incident happened, just before that or after that, whether they were angry, whether they were fighting, all of that fact become relevant so as to see whether this particular person had actually committed cruelty on his wife or not. Okay. The question is whether A's death was caused by poison. The statement made by A during his illness as to his symptoms are relevant facts. This is the first illustration, friends, which talks to you about the state of body. All the illustration that we did till now were all about the state of mind, intention, good faith, ill will. Okay, the first time we are coming across an illustration which talks about the state of body. What is it saying? The what is has happened what is the question? Whether A has died, that is a fact. Whether A died because of poison or not, that is the question. Okay. So the fact that on the previous occasions that A had made statements that he is ill and these are his symptoms to other persons, this is a relevant fact. Because in accordance with the symptoms, if someone had those symptoms, in accordance to that, he may plan his things out so as to commit murder of this person. So state of body of a particular person is becoming relevant as to the way he was killed by another person. Okay, statements made by A during his illness as to his symptoms. When he was suffering from particular illness, he was making a statement that these are my symptoms. So if this fact comes before the court can imply that someone must have heard those statements and acted on them. Okay. M. The question is, what was the state of A's health at the time when assurance on his life was affected? Insurance on his life was affected. Statements made by A as to the state of his health at or near the time in question are relevant fact. Okay. So what has happened in this case? A has taken a insurance on his life, obviously. So health insurance, when you do that health insurance, you are required to disclose all the health related informations, your illnesses, your weaknesses. Okay. So the fact that A had told all of those things which were about his state of health near the time when this insurance was taken, that becomes all relevant. So as to prove that, so what are these facts indicating? These facts are indicating what was the actual state of health of that particular person when insurance was taken. In what category of cases this fact will become relevant? This fact will become relevant in insurance cases when the company is claiming that this person has misrepresented about his nature of his health. When he took the insurance, he misrepresented that he did not have diabetes, but in fact he did had diabetes. So these facts will become relevant for such cases. Okay. Now come to N. A sues B for negligence in providing him with a carriage for hire not reasonably fit for use, whereby A was injured. Okay, so what is that? B is suing A. Why he is suing A? That A has provided a particular vehicle to B which was not fit, and because of that vehicle was not fit, or the wheel came out, or something else happened, and because of which B was injured. So that is the reason that B is suing A. So what are the facts that will become relevant? The fact that B's attention was drawn on other occasions to the defect of that particular carriage is relevant. Why this is relevant? That if on previous occasions B became aware about all the problems that were there with this vehicle, with this carriage, becomes relevant, because why did you take that carriage when you were aware of all the defects with it? This becomes relevant. Okay. The fact that, so what it is indicating, that the consumer should be, should exercise caution. The fact that B was habitually negligent about the carriages which he led to hire is irrelevant. So very important to understand that got a bit confused. So what is happening? I will repeat the illustration. And what is happening in this case? A is suing B for negligence, and so A is the person who has been injured. We got confused. Okay, A is the person who is injured, and B is the person who has provided a defective carriage. Okay, so whether he did it intentionally or not, what are the facts that will become relevant for it? The fact that B's attention was drawn on other occasions to the defect of that particular carriage is relevant. The fact that other customers, previous customers, has already indicated to B, the owner of that carriage, that your carriage is not fit. Still, he gave that carriage to B. What is it showing? It is showing negative intention, that he wanted to injure B. That's why he gave a defective carriage to B, A, knowing that it is defective. Okay. But the fact that B was habitually negligent about the carriages when he let out to hire is irrelevant. What we were talking about, this is about explanation one, right? Explanation one beside this. Why? Why? See, what we learned from explanation one. Explanation one told you that the normal conduct, the general conduct of people are not relevant. It is not relevant. What is relevant? What was the conduct of a particular person in relation to fact and issue? So the fact that B was normally negligent in his life, he was negligent in providing carriages to all the customers, this is not relevant. What is because It is the only the relevant fact is whether he was not negligent in providing carriage to A or not. What is the fact in issue? Whether he was negligent in providing carriage to A or not. Only his conduct in relation to that is relevant. The general conduct of being negligent to other customers also is not relevant. Okay. Explanation 1. O. Illustration O. A is tried for the murder of B by intentionally shooting him dead. The fact that A on other occasions shot at B is relevant as showing his intention to shoot B. The same illustration we have already covered. The fact that A was in the habit of shooting at people with intent to murder them is relevant, is irrelevant. So again, explanation 1. So what is happening is that A is being prosecuted because he had committed murder of B. And the question is whether he did it intentionally, whether he intentionally shot at B or not. This is the main question. So the fact that on previous occasions also he was tried to shoot B is relevant, obviously relevant, because it is in direct relation to fact and issue. But in the fact that he was generally, he always tried to shoot other people also, he was in the habit of shooting people, this is not relevant because it is a general behavior which is excluded by explanation 1. The behavior only in relation to fact and issue, that on previous conduct also he has tried to kill B, shot B, that is relevant. Okay, you need to always make a distinction between general behavior towards everyone and the behavior towards fact and issue. This is relevant, this is not. Final illustration, the last illustration. P. A is tried for a crime. Okay, simple. A is being prosecuted for a particular crime. The fact that he said something indicating an intention to commit that particular crime is relevant. For example, A is being prosecuted for the murder of B. So just before the crime, for example, he said that I'm going to kill B. So he said something which is indicating his intention. What is this statement showing? That he had full intention of murdering B. And if he murdered B, this statement can be brought on record and is relevant in the section 40. The fact that he said something indicating a general disposition to commit crimes of that class is irrelevant. For example, this B who was murdered was a lawyer. So if this person A did not say that I am going to kill B today, what he said that I am going to kill a lawyer today. Generally. So what is this statement? Is this in relation to fact and issue? No, it is a general statement. What lawyer, which lawyer, how will you determine? So this statement, which is about general, which is about general people generally or a particular class of person, it is not relevant. It has to be specific to the person who has actually died. So fact and issue is B, murder of B, not murder of any lawyer. Okay, that's why. So again, a good example of explanation 1. So friends, we are done with a very long section 14. So with this, I will close this video. I hope you have understood what I was trying to say. A very important section where, as far as state of mind is concerned, intention, knowledge, good faith, negligence, rashness, ill will, and goodwill. All these facts are, all these things which are so hard to prove are proved with the help of section 14 only. And the second thing is about the state of body. We saw 2 illustration about that also. So friends, if you want to appreciate my efforts, if you're liking my lectures, please subscribe to my YouTube channel and connect with me on Telegram also. I have a group on Telegram. Be a part of it. We have regular live sessions. It will be very useful for you. Until then, friends, be happy, be safe. Bye-bye.